Okay, good afternoon, everyone. We'll go ahead and get started. Thank you for being here for this second IME Advisory Committee meeting. If you don't mind, we'll just do a very brief roll call to find out who all is with us tonight. So we'll start with those here. Mindy, we'll start with you.
Good morning, Mindy Roller. And I just wanted to say that I actually look very much forward to participating. I know we went through this last time on the committee, but I hope we're able to sort of identify places, areas of contention. So it's really important that I'm excited to meet our call.
Thank you.
Good afternoon, Beth Ginsburg, the Business Council.
Matthew Mead, Stockton, Barker, Mead.
Justin Teff, Kirk and Teff.
Joe Cannabis, New York State AFL-CIO.
Michelle Cummings, facilitator. Okay. Let's see. We have White Plains.
Carl Heiser, State Insurance Trust, sitting in for Bob Sims. Rick Weinstein, orthopedic surgeon, representing on behalf of the New York State Society of Orthopedic Surgeons.
Glenn Petrozello with AmTrust Financial.
Okay, thank you. And then Rochester.
Brian Frick from Wegmans Food Markets.
Thank you. And I know Elaine is joining us in Manhattan, but we'll go ahead and get started. We'll just catch her up. So this meeting will be facilitated by our lovely facilitator, Michelle, so I'll let her take it away.
All right, thank you, and thank you all for coming. Sorry? As Clarissa said, I'm going to be facilitating today in the future meetings. And just to remind everyone that last time we were all together, we did kind of set up and propose a type of schedule, which is included in the packet that you received. And there's the schedule right there. And today we are talking about provider access. So we've broken the agenda down based on the stakeholder concerns into two broad categories: IME provider access and integrity of exams and providers. And we've devoted over an hour for each of those with the hope, as Mindy said, of coming to some kind of consensus. Before we begin the discussion for today, we want to briefly review the IME provider data as presented in the Utilization Study, as well as new analysis requested at the Advisory Committee meeting last month. These graphs and charts are also shared with you earlier in the week and are in your presentation material. Following that, we propose that the IME Advisory Committee discuss the IME provider access topics, including authorized and unauthorized IME providers, upstate versus downstate access, and high-volume IME providers. We will take a 15-minute break and then discuss integrity of exam and providers, including training, exam preparation, credibility of reports, IME non-referral lists, and overseas reviews. And finally, we will confirm whether consensus was reached on any of today's topics, and also briefly review the proposed topics for the April agenda. As discussions are progressing today, if there are issues raised other than those associated with providers, we will also be adding them to a parking lot to be added to the agenda of a future meeting. I will now turn the meeting over to Stephanie to review the IME provider utilization data. Recognizing that it is a lot of information, if you have questions as she is going through the data, please feel free to ask as she moves through the slides. Thank you.
Thanks, Michelle. So this slide recaps the 5 key points from the IME Utilization Study related to IME providers. Specifically, in recent years, there's been a drop in the number of authorized IME providers. Certain parts of the state have few or even no authorized IME providers. The majority of providers who performed IMEs actively treated injured workers. 72% of the IMEs were performed by just 2.5% of eligible authorized IME providers, and the majority, over 80% of IMEs, were performed by orthopedic surgeons. This chart was included in the IME Utilization Study. It has now been updated to reflect the current count of authorized IME providers in New York State. At the end of February, there were 4,270 providers authorized to perform IMEs. As I mentioned at the kickoff meeting in February, there were over 3,000 IME providers who were suspended due to failure to register. Since that time, approximately 160 have registered and are again authorized to perform IMEs. However, as shown in the slide, the overall IME provider count has continued to decline. As a reminder, this slide shows the percentage of IME providers who actually performed IMEs during 2014 to 2016. The yellow bar shows the count of those authorized IME providers who performed one or more IMEs. For example, for orthopedic surgeons, the top bar of the chart, approximately 79% of the 671 providers performed IMEs. A total of 2,089 authorized IME providers submitted at least one IME during the 2014 to 2016 study period. In addition to the 2,089 board-authorized IME providers who performed IMEs during the study period, there were over 2,000 IME providers who are not authorized who also performed IMEs. This slide shows the number of unauthorized IME providers in contiguous and other states, as well as the count of IMEs that they performed during the 3-year study period. Note, a provider can perform services in multiple states, so they could be counted more than once in the above categories. Additionally, there were 175 unauthorized IME providers who performed 710 IMEs within New York State. Most of these were dentists. You've also seen this slide in the utilization study. It shows the count of IME providers who performed an IME in each New York State county. Darker colored counties had the highest count. Lighter colored had proportionately fewer. As previously mentioned, some IME providers travel and perform IMEs in several counties. Thus, some IME providers are counted multiple times in this map. Over the last month, we performed additional analysis on individual IME providers and noticed that some were listed more than once in the IME entity data. We eliminated the duplicates and adjusted the counts on this slide. Soon they will also be adjusted in the public utilization study. Although the provider counts were reduced, the county-by-county ratios are similar. Note that if an IME provider performs IMEs in multiple counties, they will be listed more than once. This slide shows the relationship of total IMEs performed by the total number of IME providers who performed at least one IME within each workers' comp board district. If the distribution was proportional and all IME providers performed the same number of IMEs, then, for example, in Binghamton, each IME provider would only need to complete approximately 29 IMEs per year in that district. In Queens, the district with the highest volume of IME providers, each IME provider would need to complete approximately 53 IMEs each year in that district. Note that to the extent that providers perform IMEs in multiple counties within the same districts, the counts would need to be modestly increased. This slide was also in the utilization study. It shows the count of authorized IME providers who performed one or more IMEs during 2014 to 2016. Again, 2,089 board-authorized providers performed IMEs. 122 of those were authorized only to perform IMEs, and the remaining 1,967 were authorized to both treat and perform IMEs. The last column shows the percentage of IMEs performed by each provider type. It shows that 86.5% of IMEs were performed by IME providers who also actively treated injured workers. This slide was also included in the utilization study. It shows that the percentage of IME providers who also treated by their specialty. This slide shows the percentages based on provider counts, whereas the prior slide shows the percentage based on IME volume. This slide was also from the Utilization Study, and it shows the distribution of IMEs by specialty type. The vast majority of IMEs, over 80%, were performed by orthopedic surgeons. This slide generated a lot of conversation when we met in February. We added the last column, the average payment, to the analysis. This shows that the higher the volume of IMEs performed, the lower the average payment is. As you may recall, the average payment for all IME services was $571. There was a lot of interest in the demographics of the providers in the high volume categories that represent 72.5% of the IME volume. Thus, we'll show some additional detail on this group in the following slides. This slide shows additional detail on the 104 providers, the 2.5%, who performed 72% of the IMEs. There are 78 who are still active in 2019. The other 26 have either resigned, been revoked, retired, or did not renew their medical license. The 26 IME providers who are no longer performing IMEs are highlighted in handout number 1 for your reference. This table summarizes by specialty the count of high-volume IME providers in each of 4 categories. Those who performed only IMEs, those who performed IMEs and were active in treating both workers' comp and health insurance payments for patients, those who performed IMEs and were active only in workers' comp, and finally, those who performed IMEs and were active only in health insurance. Underneath each category, 5 years of IME volume is shown from 2014 to 2018. Slightly less than half of the high-volume IME providers only performed IMEs. A little less than a third performed IMEs and were also active treating both workers' compensation and health insurance patients. Note, for the health insurance participation, this was verified solely by matching the providers against Empire Plan claims data maintained by civil service. We do not know the extent that these providers may be active with other health insurance, nor how active they may be with other types of exams such as no fault. There are additional details about these providers on handout 1, including the median and maximum number of IMEs performed per work day and the estimated number of service locations. We also took a look at other high-volume IME providers who had more than 1,000 IMEs during 2017 and 2018. Similar to the previous slide, this shows 5 years of IME data for the additional 24 providers. Most of these providers did not perform a high volume of IMEs during the study period, but in recent years have performed more. In contrast to the prior slide, 2/3 versus 1/3 of these providers performed IMEs and were also active treating workers' comp and health insurance patients. Detailed information on this group of providers is included in handout number 2. So this concludes the presentation on IME providers, and I'll turn it back over to Michelle to facilitate discussion on provider topics.
Step
Sure.
Please.
Did I hear you right that the average cost of an IME, did you say 517 or 571? 571. Okay, thank you.
Just in terms of the general topic of availability, the 3,000 that were suspended due to failure to register, and I'm guessing that there's no data, but any indication as to why they chose not to re-register, why they did not want to participate in the process anymore, or simply a default on the registration?
They were given multiple opportunities to do so, and they failed to register. We don't really have any other information on that.
Fair enough.
One more question. Does the IME data include IMEs that are responding to variance requests?
Yes.
I was going to ask that as well. So we are discussing carrier medical providers, professionals within that auspices, not just the straight IME as defined by...
Well, it's anything that would have been received by the board on an IME form.
Okay.
And
Okay.
variance requests,
So,
you know.
so no.
Well, not the
Some
variance,
don't.
not the variance, well, if they ordered an IME in order to respond to a variance request, and it came in on an IME 4, then it's included in our data.
Then you capture it.
Right.
But if it just comes in attached to an MG2 denial of a variance, that would not be
Yeah,
captured.
the medical professional involved in that process that's not an IME is not counted here.
All right,
Okay,
thank you.
All right, is there any other questions regarding the data that Stephanie presented?
Yes, thank you. For the slide on page 14, where are the Power 10 in here? You know, the 10 folks who do, what was it, 6,000 to 9,000 IMEs?
Yep, so if you look at handout number 1, this lists the 104 providers, and the providers that would be number 1 through, no, actually, well, the top 10, handout number 1 is in the order of the highest number of IMEs, and so they're going to be in the top 10 on this listing. So, like, I'm pretty sure that number 79 right at the top is one of the 10. But there were 4 out of those top 10 that are no longer performing services in 2019.
If you look at column 6, where it says total IMEs, so it's arranged by the highest number of total IMEs.
Okay.
Joe, is your question though, where do they fall on the IME only, IME Health, WC, et cetera?
Yes.
Yeah, that's what I.
So for those folks, are they IMEs only? IME Healthcare, Workers Comp, IME Workers Comp, IME Healthcare? You know, where are they? Are they only doing IMEs?
In the top 10, it's going to be well, it's going to be number 79, number 2, number 3, number 81. It's on this handout number 1. And so if you look over to the right, all of those are doing both. And you can see there's also a column for how many claimants they treated in workers' comp, and then whether or not there was a match to health insurance records.
When you say treating healthcare, is that private health insurance?
That's private health insurance, but it's only the Empire plan. That's the only data that we were able to match against.
Okay.
Excuse me,
And
and, I'm sorry, what did that go ahead?
this is the significance of the highlighted lines.
The highlighted lines are those that are no longer participating in 2019.
Okay. Thank you.
Mm-hmm. Those are the 26 that I mentioned previously that are no longer participating.
Mindy,
No, that was
a question?
my question.
Okay. Any other questions on the data? Okay, so we mapped out some suggested conversation points for today's discussion, and they're listed on the slide. And I guess the biggest question that has come up in the stakeholder meetings, looking at the data, is from an industry's perspective. Do you believe that there is sufficient number of IME providers overall, given the data that we've been able to accumulate?
It looks to me like there's an upstate, downstate issue with the availability of providers.
Okay.
That at least a couple of the upstate counties have no resident providers, and
Some of those counties have next to no employment, of course.
right, of course, but unless you're near a metropolitan area, the availability of an IME seems to be limited.
Justin Teff, I will say from the claimant's perspective, that tends to be our experience as well in upstate. Generally, a client is not going to have to drive more than an hour to go to an IME, and the carriers are very decent about that and respectful. But obviously, the further you get into the hinterlands, the more difficult that becomes. And certainly for a client with a bad back or status post failed surgery, to drive an hour and a half to an IME is an undertaking. So certainly, I guess I would agree with the general sentiment that it would be better to have some outside of the metropolitan areas and more in upstate New York.
Lev? I'm sorry, Whitney, you had your hand up.
Yeah, I just wanted to say that actually I think that we need more IMEs generally. Even within the city, we don't have enough IMEs, and I think that causes fewer IMEs available means that more of them have to do more IMEs, and that contributes, I would imagine, to the skewed statistics we see.
I'll add one notion to that. The harder it is to get an IME, I think, and we'll discuss this later, the more likely a carrier will need to provide a records review or something like that, which from an attorney's perspective, forgive me, we deem to be about the lowest level of available proof on a medical issue. And so to the extent we can have an actual IME versus a records review, that is a good thing from the claimant's perspective.
Do you have any issues or concerns regarding just the availability of IMEs?
No, I mean, obviously, there's always going to be an upstate-downstate divide. I think that goes without saying. And the third bullet point, which we've already touched on, which is provider availability in rural areas, I think that, it very much mirrors every other medical professional in those communities. I mean, we have, as a state, a problem with a lack of providers generally in rural areas, and I don't think that it's necessarily an IME problem. Not that we can't work to solve that, but I think that, we need to sort of keep that in mind. We can't, I'm not sure exactly how we place bodies in places where there aren't, so just keeping in mind.
How about you folks, Rochester? Do you have any?
Well, my question is there's two different questions. Are there enough IME providers in the state, or are there enough IME providers in selected areas of the state? I think maybe overall the state, you might have enough providers, but in areas like Plattsburgh, maybe there's not enough providers for chiropractic IMEs because it's such a small area. So maybe if you had a look at, as a whole state in general, do we have enough providers? That'd be my question, let alone what specific areas. So looking at the data, the top 10 providers, power providers, we lost a lot of them. So that would probably tell me that we don't have enough. If we lost those providers doing that much volume, we probably do not have enough providers. So those are just my things.
Well, it sounds like so far, I mean, we've identified that there is an availability issue. It's not, in fact, just upstate, it's also downstate. But how many potentially we need and where we need to focus actually leads nicely to the next question that we have up, which is to the extent there is an availability issue, is it all specialties? Is it certain specialties? Or what's people's feedback or insight as to the level that people may need something other than an orthopedic surgeon? Are they able to access IMEs?
Before we move on,
sorry, I figured you'd jump in.
I think it would be helpful to think of this not as a problem with the number or the overall number, but rather how do you incentivize folks who are doing 1 or 5 to be doing 10 or 20 or 30, and disincentivize the folks who are doing 2,000, right? This shouldn't be their sole source of business, and I think that's from our perspective where the potential bias comes in. The other thing is we don't want injured workers, failed back surgery, to be driving an hour and a half or 2 hours. We want those people to not only be able to get an IME closer, but also care. How do these numbers compare to treating providers in the state?
Is that something we could?
Is it disproportionate here? Or when you look at those upstate counties where there's 1 IME provider, 0 IME providers, does that correlate to what you're seeing on the numbers for medical providers, that those injured workers there are underserved regardless?
Actually, I think that's a good question.
Yeah, we haven't looked statewide, but I know we have looked, say, in the Messina area, and there's enough orthopedic surgeons, it appears, to treat claimants, but then, you know, it's harder to get an IME provider with an orthopedic surgeon background to do an IME there. So they bring in IME providers. So it's...
Rather than have the carrier bring in IME providers from other places, what can we do to incentivize? It seems like there's plenty of orthopedic surgeons there treating injured workers. How do you get the orthopedic surgeon that treats that worker to perform the IME on a different worker? I think that also is pretty well reflected in here, that those power providers are, they're not treating anybody. So how do you get the treating docs to do IMEs for people who are not their patients?
Is it possible to do that through the authorization process?
I'm asking questions here. I'm not.
Yeah, so am I.
You know.
Hey, it's Rick Weinstein. I'm probably the only orthopedic in this committee. I can speak from my own experience and the other orthopedists who do IME exams for workers' comp. It is a difficult. It's different than treating a patient in the office. It's a difficult process because it requires a lot of time to review the records as well as a different kind of examination. Patients are not there necessarily to get better, so it's more of a combative examination rather than a friendly exam. So some orthopedists are not eager to do it for that reason. And it's also the financial incentive has to be there, and I think the incentive was there financially, and it wasn't as painful a process time-wise. I don't think it'd be difficult to recruit orthopedists to do it. But there also needs to be education, because I think a lot of doctors who would do it just don't know about it, just haven't been educated.
And I'll just add something to that, which may or may not be a point we can get through. That, in addition, requires, I would think, an additional administrative structure within any orthopedist office. First, someone who knows the regulations here to a T, so that everything can be complied with. You know, from well, now I've been on the carrier side. If the IME doesn't follow the rules or does something wrong, I generally would think that IME would not be valid. Well, that's it.
I had two thoughts. Well, one is just less than a thought. It's a bit anecdotal, but I've done a lot of work in health policy, and the maps really do correlate. I mean, it's anecdotal coming out of my mouth, but there are organizations like AHEC, for instance, that have very accurate counts of providers in all of these counties, and it would probably be helpful if we got that as an overlay, so we could sort of compare them. But I really do think that in many respects, this is it's simply a problem of numbers.
Do you already have access to that maybe you could share with the committee?
Not on my
Not
person,
on you, but you could get it to us?
I'm sure I could get
because I think that would be, you probably save these guys, all of us a lot of time. If you could share it with the group, I think that would be great.
I will dig some stuff up. And the other interesting thing I think that stands out to me, and I don't disagree about the concept of incentivizing folks that are doing less to do more, and perhaps vice versa. But when you look at the payment structure or what the average costs of IMEs are, it goes up significantly higher and higher to the folks that are doing less and less IMEs. So it strikes me that the people that are already doing fewer IMEs are making significantly more money per IME. So I'm not sure that there's a financial incentive built into at least the data that we're looking at. Because even if we doubled the average, which would get us to about the highest mark, they're doing 5 IMEs. So it's just we to be mindful of it, and I'm not. It just jumped out at me as we talked about incentivization. I think administration is probably as important as anything else, as you sort of mentioned.
So is this I think that you're assuming that it's a cause and effect, right? Because they do fewer,
no, I just said a point. It just jumped out at me.
They get paid higher. I would imagine they're extremely specialized fields, and there are very few of them, at that top end that are doing 1 or 2,
perhaps,
right? So they're getting paid significantly more.
No, I don't agree with that.
Well, then, if you can,
yeah, elaborate, please. We're going to go back to White Plains South. Go ahead.
I'm sorry, it's Rick Weinstein. My thoughts are that if you do a lot of IMEs, you probably have a system in place, like someone said about the administrative, and that's really important. So if you do a lot, you have an administrator or a system in place that makes it much more efficient to do it in the office. If you're only doing a couple a year, it's a very painful process to figure out what you have to do and how to do it. So I think the improvement in efficiency comes with higher volume. So I think I think we'll all have a consensus at the end of this discussion that the high volume guys are doing too many. But we do want to incentivize the low volume guys to do more, but not too many.
So I just want to follow up on that. Recently, I've met with all my own IME vendors, and I really do agree. I think it's the administrative aspect. It's really, frankly, onerous. I remember before IME vendors were essentially required, the city used to have doctors who were extremely well respected at the board, routinely doing IMEs for us. And it was not so difficult to administer the whole program. So that now you're forced to use IME vendors. There's a lot of layers there's more layers of administration. And not only that, but it often, as was said earlier, the report actually just gets precluded because there's some technical defect in it. So I think that it's the administrative aspect of it that's really makes it really not at all attractive to doctors.
Well, what is it about the administrative? Like, is it just because there's so many different things,
requirements? There's a lot of regulations.
And following up on what he said.
Right, there's a lot of regulations, there's a lot of forms, there's a lot of timetables. If you're doing straight, even forget about regular health insurance, you're doing an IME for liability, there's no deadline, there's no forms, and you get paid much, much more money for it. So why would a doctor who's capable of doing an IME do an IME in workers' comp? Unless he's part of a network that facilitates the administrative aspect. Frankly, as an employer, it's not of any benefit to us. We're not happier with this system at all. But I think that the result is, and that's why in like a city like New York, even though there's like a jillion doctors, we don't have a jillion IME doctors to choose from.
Okay.
If I could add something to that. Before 137 was in effect, I had a client that set out to get the head of the department at teaching hospitals to do their IMEs. And they paid a lot of money for those IMEs, and they got very high quality IMEs. But since the IME 3, 4, 5 family of forms and the regulations regarding the timetables and who has to be served and how they're served, it's impractical anymore to seek out those doctors.
Okay.
Or perhaps if there was some form, not that I don't often like when the IME is precluded on a technicality, but let's speak in the interest of justice here. My office has been asked by solo practitioners to educate them as to if they wanted to do IMEs and if they were to secure the license and the registration with the board, what do they do? How do they deal with these processes? What are the timetables? What are the forms? When do they have to be submitted? How do they have to be submitted? Same time, same manner, within a certain number of days with a certain certification. And frankly, I scour them. If one point is off, I'm more than happy to raise it. If there were something of a more formalized education process for people that were interested in doing something like that without having, I mean, you need a lawyer, you really do, to have assist a doctor.
But if you were a doctor, would you go to such an educational meeting and hear all the requirements and say, "Ooh, great, sign me up"?
No, but if I were a doctor that said, I think I want to do this, but I'm not sure, I just don't even know how to go about this or what I would have to do, at least it would be a start.
If I were a doctor, I certainly wouldn't do it for $517 a pop.
That's
Right.
another issue entirely, of course.
Right, I think that makes a lot of sense. The education, I think, is very important. And if the doctor said, I'm going to make $1,000 for each of these that I do, I don't mind giving up 4 hours on a Saturday to learn how to do it the right way. We'll be required to do that.
Dave, forgive me, there's no IME fee schedule.
And
Okay.
Also, Carl, I think that, you know, another element that we're not mentioning, but it's very much a part of our business, and it's just thinking it from the institutional carrier side, is, we have the vendors that are acknowledged in the rules as players with respect to being intermediaries with respect to the actual provider of the service. And it seems to me that the cart's before the horse, the concerns of those vendors sometimes become preeminent. And, and it's unfortunate, I think, and it works it harms the carriers, it harms the claimants, and I think it harms the medical providers on both sides, whether they be treating or consultants, because a huge percentage of the fees that get paid for consulting exams, IMEs, go to these administrators that, frankly, I think add little value to the process. And I mean, and we also see that there's a great deal of redundancy, certainly downstate and where I am. We see a great deal of redundancy, in terms of the list of providers that each vendor presents. So irrespective of who you go to, you get the same list. They may be compensated slightly differently by different vendors. But so it becomes extremely frustrating at times, because I think everybody, and I would hope to think everybody, would like to have credible medical evaluations. That's what we want. I think I'm certain that anybody operating in good faith in the system should want that. And the technical requirements that the rules impose and the law impose, to some degree, work counter to that.
I just want to make sure I'm understanding your point correctly. Are you saying that to the extent someone is an authorized IME provider, they then turn to a third-party consultant to work on the evaluation, or are we talking about unauthorized?
No, of course not. That's prohibited.
Okay.
But the administrative function, the filing times,
okay,
and also these providers also help the payers identify quickly evaluators.
Okay.
It's obvious there's some convenience involved, but I think that if the individual physicians had an easier time navigating the technical requirements, I think we could readily engage those practitioners directly.
Right.
And I think that would be obviously, for all involved, optimal.
So that's, just to follow up, that's sort of what I was saying, and I want to add to that as well. First of all, the IME vendors, when you talk about how much money the cost of each IME, that does not represent what the doctor gets. That's $571 going to the IME vendor, who then, I don't know what their arrangement is.
Okay.
So you're not talking about how much the doctor gets at the end of the day. However, well, let me just say, what I've recently found out, which I was really unaware of, was I have IME vendors. Why do I have? I don't contract or have any relationship with the IME doctors at all. And as a matter of fact, with the city, because of the nature of what we do, it's a rotating wheel. I don't even know which one of my vendors is going to handle it until it tells us what we're going to use.
Okay.
Having said that, so I don't have no choice over which IME doctor it goes to. And I agree with Carl. We see the same doctors with all the various vendors. But what I was going to say is, evidently, it's not even the vendors. The doctors themselves often have groups of doctors. So there's another layer there where they have somebody helping them do the administrative work that the IME vendor actually deals with, not the doctor directly, but the doctor's, front office staff.
Okay.
So that's what I meant before when I said there's lots of layers between us and any IME. I'd be much happier myself if I could go and get the head of every department in a city hospital and say, okay, can you do this IME? I'd prefer to pay more for better quality and not have to go through this system that's so onerous, as I said before, that I think that would be to everybody's benefit.
I just wanted to clarify, Mindy, when you say IME vendors, you're talking about the
IME companies,
the IME entities that are the middlemen between the doctor and the
But indeed, there's actually another intervening layer, as I understand it. For some people, I can't, speak to everybody's form of business, but the point being that and again, it goes back to the whole problem of the nature of compliance. A doctor isn't going to be busy, putting 6 envelopes in the mailbox by himself. And I'm not saying that that's not necessary, that's another conversation, but it's just very, very, you know, administratively unwieldy, I think.
Okay.
No, but that is this conversation. You know, and I hesitate to get into particular points, and I don't think deregulation generally is a wonderful thing, you know, given my proclivities, but, you know, it strikes me that if the requirements were a little bit less onerous, with the notion that carriers, I imagine, would desire quality medical reports. It's very easy for me to cross-examine a medical doctor that didn't do a good job. It's very difficult when they did. And I guess, well, nope, sorry, I'll let that there.
No, I think your point is very, very well taken. I have no interest in paying $571 for an IME that's useless, valueless to me, that the doctor, no matter what he says, you know, I can't, he's not going to be available for deposition, he's not going to be able to articulate and back up what his findings are. Why would I want that? I would much prefer a good quality IME, and it is what it is. You know, if I could rely on my own doctor to tell me, I don't mean to sound, you know, to tell me the truth, but to do a good IME, to evaluate somebody honestly and tell me what's going on in the case, then I know what my case is about. If I have an IME that I look at and I say, this just doesn't jive, then I'm in no better position than I was. I'm probably in a worse position than I was to begin with. So I think that again, I think it really goes back to this whole concept of the administrative, you know, difficulties that the current IME system requires and creates.
I'm guessing, and I did not really give this deep thought, and certainly no actual study, but that 137 and associated regulations may have been fashioned in an era where we were just a little less tech savvy than we are now. 2000 was a much different time than 2019 in terms of, I mean, I did not have a small computer that I carry around with me in 2000, I don't think. I don't know how that would necessarily coordinate with the various regulations, or with perhaps making it a little less onerous for quality medical providers to enter this forum, but certainly it's a consideration.
Is there, this is a question I don't expect an answer to, but is there room to utilize the medical portal as an avenue for the filing of IMEs? I mean,
well, I think our charge is to come up with the areas that you can do, at least starting to agree on. And then the next steps could be, you know, what do we do to potentially implement those, whether they be regulatory or they be legislative. So that is something that could be explored.
Right, it could be, and I think the answer, just literally to answer your question, is yes.
Okay. All right. Easy. I also want to say some of these concerns are a little bit about process, and we're supposed to talk about process a little later. So I don't know if we want to just move through these and see if there's anything else that we may want to highlight here, given the data that we've received, and then maybe go back to a lot of these like really important process questions that have
On the provider issue, I'm at a little bit of a deficit. I'm not a practitioner, and I'm one of the few people at the table who's not. Is there a benefit? I mean, I know there would be for me. We're talking about IME providers, we're talking about doctors, and then we were talking about companies, we were talking about your vendors, right. Mindy. And I'm guessing, and I don't know this, that there's different business models for those vendors. They don't all operate the same way, right?
And they market aggressively at times.
So is there a value in our having an opportunity to learn about that?
The different structures
that
are out there?
The different structures, how they operate.
Well,
I mean, it would be worth it. It strikes me that, you know, we're talking, they're an overlay. There's no question about it when it comes to providers.
I totally understand, because what you're looking for is, in effect, the flow chart of the different models that
correct,
are
and then
like, you know, what works, you know, what is the primary model, and then what are the extensions.
I don't think there's a big difference between what they do and how they do it. I just think there's a variable in where they work, which counties, and how big they are. So I think they all have the same model. They work with the doctors to get they do the administrative part for the doctors, basically.
Yeah, but I think if I'm understanding like some of the comments on the administrative stuff, and again, bear with me for a second, people are in fact hiring consultants to do the administration and to do all this extra paperwork. And so does that become a barrier to having more IMEs generally? That's what I think you're kind of.
Well, I'm hearing from a lot of different folks from different walks that, the administrative burdens are really one of the major catch points and hurdles. And I'm also hearing that these companies are filling in that void and doing that job of by and large doing that job of filling that void. I would like to understand more how they do it. Well, what's there's a value add there. Right. What's the model, and and it might be worth having the opportunity to learn more about it, maybe from those companies, or maybe a breakdown from the board. I just think it's part of this conversation. It's difficult to escape it.
Lev, I do want to just say though that every single one of the IME vendors did contract with these high volume providers. So there's
and probably some of the low volume providers as well, right?
Yeah.
I mean, that they contracted with the doctors who are out there, I would imagine. But I'm trying to sort of mentally decide, and good, bad, and ugly are not the right words to use, but there are probably differences. There are probably differences in some of the kinds of doctors they use. These are probably important, if we're actually going to come up with ideas for solutions. This is that's a big part of the process, obviously. It's the gap between the employers and the doctors and the lawyers. I mean, it's that they're right there in the middle. So, and we're not hearing from.
I heard my name being called from one of the screens.
It's Brian and Rod.
Hi, thank you.
One more thing about vendor companies that we talked about. Two things. We talked about some of the problems are administrative burden and training. I think that's the two biggest functions that an IME vendor company brings to the table is they train the doctors, they do the administrative work. So I think we just have to keep that in perspective as we talk about this.
Okay, and we will be talking about training some more after the break.
So I just wanted to check if I'm right, David, maybe you would know off the top of your head. Before 137 essentially requires IME companies. Is that, or is it, can you still contract directly?
No. Yeah, you can. I mean,
it's just that the nature of 137 made IME companies necessary because it became
so much
complicated.
Easier to use them.
There's no question that back office work, I mean, everything other than the IME 3, it's much easier to run through the entity.
Right.
I mean, much easier. And so I think it's a combination of the regs and 137.
Okay.
Just scanning 137, I don't think the term IME entity is mentioned in the statute.
But
it's not.
No, but that was the natural outgrowth of 137. Right. I mean, one of the results was the IME company.
Yeah, the notice requirements, the filing requirements that are referred to in 137 definitely make it easier. And so the reason it was put into the regs was because there needed to be a mechanism to have back office work done without it being considered a violation of confidentiality.
Right. Okay.
So that's why it regulated.
What kinds of things do you think would be helpful to facilitate that discussion about the IME entities? You guys have the option of bringing in other subject matter experts if you like, or we can gather additional data. You tell us and we'll see what we can find.
I mean,
I would invite one or two of the IME companies to come in and tell us what they do. Maybe.
They probably would, yeah.
If you guys have anybody in mind, we would appreciate suggestions as well.
I mean, we might, I have none in mind. I don't utilize them, but, maybe a higher and a lower volume. I mean, that's sort of part of what we're talking about, right?
Yeah. And if you guys think of folks after the meeting, let us know and we can invite them. Does anyone in White Plains have anything to add about what else could facilitate this discussion in particular?
One thought I have, and it's a version of what I said earlier, is, and with what David said too, we have a situation where we speak in the law about medical evaluations and doctors who perform medical evaluations. And then when we apply that effort, when we try to obtain those evaluations, we have an inversion, it seems to me. The inversion becomes, the administrative convenience becomes preeminent. And the medical evaluation, the providers of that evaluation become subservient to the vehicle by which we efficiently convey the data. And at some point along the way, when the professional endeavor and the evaluation and the assessment of these injured workers' conditions become secondary to the convenience of the process, there's a fundamental flaw, and I think it's a structural flaw. And I don't know, I mean, I'd be the last one to say I have some kind of magic formula to figure out how to do it, because clearly there's a high volume and a need for efficiency, and certainly we have to honor that. But I don't know, but I think as long as you have these vendors there, the doctors essentially, when the payers deal with the vendors, the business side of this starts to damage the product, for lack of a better word. And I can say that just locally, that's how I feel. And we certainly, out of our location, engage a lot of doctors that do a lot of IMEs. So I mean, it's not an answer, but it's a concern, and I don't know how you navigate it. I understand where the regs come from, I understand the validity of the intention, but somewhere along the line it got subverted.
So I have a question.
Sure.
And it's sort of building on something that Joe had said last time and he said this time, and it's about an inherent bias when you're doing a high volume. And I'm not even necessarily disagreeing with Joe on that idea. But so, because the last bullet point is there a problem with the disproportionately higher volume IME providers? So we know that there are small numbers of folks doing lots and lots of IMEs. Do we have any sense at the quality of those IMEs? In other words, is there data, I don't know if it's remotely available from the board, but do we know how often a judge does not side with those particular IMEs? Is there any way to sort of parse through decisions to come up with some kind of ratio or correlation?
Wait.
So,
I have to interrupt.
Let me
I don't
just
think
finish
a judge going
let me just
in favor
finish
of
the
one
thought
or
for one
another
second.
is necessarily dispositive of anything.
I don't disagree with you. And
Sorry.
I'm just looking for some ideas of correlation so we can argue about it, and you may very well be right as well. We can argue about it later. I'm just looking to understand whether or not a high volume IME provider is necessarily a poor one.
Right.
And I'm looking for suggestions on how we sort of arrive at some way that we can sit down and determine that. Because I'm not sure that it's true. But the other point I think I was thinking about that is that the market, I think, may have a tendency also to work, because you brought up the business side of things. It strikes me that there's a market out there for IME providers, right? Those that are providing garbage IMEs are going to be specifically not requested by you, correct, Mindy? I mean, if you know that Dr. Ginsburg puts out garbage, you're going to make sure that you never use Dr. Ginsburg again. So there is a possibility.
There's a market correction in
there may be a market correction. I would think there is a market correction in and of itself. So I'm just interested. I don't want to take just as a given that high volume providers are bad.
Are all bad.
Right? I mean, I want to find a way, and I'm putting this to the board, and certainly Mindy, by all means now, yes, you can tell me I'm wrong. But if we can find a way to try to
No, I think
find
it's
something like
it's
that.
well taken. I just don't think that whether or not you prevail or don't prevail at the end of the day is necessarily a measure of the quality of the IME.
If you never prevail, then.
As a provider, as not just the IME doctor, when I'm working seeing my patients as an orthopedic surgeon, and I know they're going to an IME exam with a certain physician, and most of these are high-volume physicians, I know they're going to have the result against my patient. I know they're going to immediately say, "You're fine. There's nothing wrong with you. Go back to work." I'm not saying it's 100% of the high volume providers, but a fair number of them, their job, as they view it, is to deny treatment and get them back to work, regardless of how the patient is actually doing. And a lot of the patients will come back and say, he didn't even touch me, he didn't even examine me, he spoke to me for 1 minute, didn't listen to me, and kicked me out. So my concern is, I agree, there could be some good high-volume guys out there, but I think there's a lot of bad high-volume guys out there who are just trying to make money, get people in and out, and not give a fair, appropriate report.
So following up on what Lev said, does the market inherently cause people not to utilize them?
No, it's the opposite.
Yeah, I would tend to
It's the
agree with
opposite.
that.
Okay.
What does that mean?
That means that the doctors who give those reports will be referred more people for evaluation because they're giving those reports saying they have to go back to work.
Okay.
I have seen some IMEs that have given very favorable opinions to workers over the course of years who no longer are hired. And that is not a slight against the business community, not for one moment, but it is a problem inherent in the system. And to your point, I absolutely agree. I think it's just the word necessarily. It's not necessarily that the high volume is bad, but as a general concept, I think quality and quantity are inversely proportional. And so the more you do, the less quality it's going to be. That probably is worthy of
So is there a way that we can work to quantify it? I mean, that's, I hear what you're saying. There is.
I think that's an important point. The volume that you do may be inversely proportional, but a very low volume, I think, will also be of lower quality. So I think there's got to be a middle ground. If someone who does just 2 or 3 a year, they're probably not going to do as good a report as someone who does 50 a year, 100 a year, because the person knows better. And it might be related to the regulations we have to abide by, but just to do a better, more accurate report.
I mean, I'm slightly troubled by the idea simply because I have friends who are orthopedic surgeons, actually, and some other kinds of surgeons, plastics, etc. They're extremely high volume. They're very busy people. They spend 16 hours a day in a hospital, 4 days a week doing surgeries with minutes break in between. I don't know that I would necessarily qualify, them as, low quality because they're doing high volume. I'm not sure that you would feel that way about yourself, doing surgeries either. I'm concerned that we're just saying these things anecdotally and we're not looking at any data whatsoever to show me that it's a problem. And I'm not a practitioner, so I don't know.
Yeah.
But I want to know.
But I've been looking at the detailed handouts that we were provided and seeing that an individual doctor performing 7,000, 8,000, 9,000 IMEs a year. Even if I said a doctor would work 260 days a year, which would be 5 days a week, 52 weeks a year, and did the division, the volume of IMEs would be daunting. How that could, in any, except for some kind of peculiar outlier provider who may be a savant of some sort, how they could, so I'll be open to the remote possibility that that person exists.
Well, aside,
how can generally you expect those to be good quality? I don't know.
Aside from the dirty dozen, I don't remember the term you used, Joe, but I like it.
The Power 10.
The Power 10. Aside from the Power 10 or the dirty dozen or whoever, they start. Those numbers are pretty out of skew. But when you get below those, they are well within the realm of possibility. And also, as I look at the Power 10, I mean, 1, 2, 3, 4, 5, 6, 7, 8, 9 out of the top dozen are no longer in the system. So, I mean, we're talking about the Power 3 now, or the whatever we want to call them. So, I mean, I think that this problem may be taking care of itself. But now we're talking about people who are not doing 10,000, but we're talking about people who are doing 6,000, which may actually be an approachable number in reality. So I want to sort of shy away from the absolute extreme and sort of delve into what does this actually mean.
And those numbers are five-year value.
Yep.
So, it's really 2,000 a year,
Right.
2 or 3.
And many of them are now gone.
Yeah.
Right.
So a couple points. One, if you take a look, the Power 10, we've got some up-and-comers here, right? Some folks who are doing significantly more did 0 in 2014 and then 3,200 in 2018. So we got some people ready to take those top 10 spots again. As far as the idea of volume, I think it goes back to a comment earlier, which is what they view their job as. If your friends who are plastic surgeons view their job as performing high-quality surgery, helping people, orthopedic surgeon, performing high-quality surgery, helping people get better, then high volume isn't necessarily a problem. But here, I think that high volume can be a problem if they view their job as denying care, denying claims, and keeping the carrier's bottom line healthy. So I agree, high volume in anything is not necessarily bad. With high volume, you get great experience. But what is the experience doing? Is it the experience to treat people, put on cases, or is the experience to deny claims? So that's part of the difference here. In my mind, those are not apples to apples.
So I have a suggestion and a thought about something that was said just a little while ago. My suggestion in terms of what Lev is saying, and I think it's a really good question, is why couldn't we take some of the reports and frankly have somebody, maybe the medical director's office in Lane, review, a random sampling of IMEs to see, does it hit all the points that an IME is supposed to hit? Does it address every issue that an IME is supposed to address?
So I think that would only go so far in assessing quality. I think that we do have to take a look at maybe outcomes, right? You said earlier that you didn't think that just because they were overturned by a judge was dispositive of the quality. The quality of what? The quality of the exam? Does the report reflect the actual condition of the injured worker, or are you talking about the quality of filling out the forms? Because the quality of filling out the forms is
filling out the forms.
Or
quality
completing.
of the medical.
I'm talking about the medical findings.
So here's the thing: if you look at the document, right. Without context, without having a decision maker say this is accurate or inaccurate, then all you're looking at is how well they fill out a form. So I think that we're working with this fiction, right? That and this is like pretty much every legal proceeding, that the facts are what they are, right? And once you go through the proceeding, all of those facts have been determined, the law has been applied, and that is actual reality, right? That's what we're talking about here. And it doesn't matter what proceeding it is. At the end of the day, when you've exhausted all your appeals, you have what is determined as
that's the law of the
injury.
case. I'm not so sure that that's...
So here's the thing though, what else could we possibly go on? If we're going to assess quality, I think that we have to look at outcomes. We can't just look at a piece of paper, totally separated
So
from the
back to
outcome of
that.
the case, or what the judge decided, or what the board decided, or what the third department of the Court of Appeals decided. I don't think that you can look at one and not consider the rest.
Except I just want to point out that, going back to, you said earlier, a report that's favorable to the employer. And I think that that's the wrong litmus test. Not what's favorable to any party, but what seems to reflect somebody's medical condition most accurately. And after all, I would think that that's really what everybody's most interested in.
So Dr. Weinstein talked earlier about the difference, when we were talking about why we can't get practitioners to conduct IMEs, he talked about the difference of the nature of the encounter, right? I believe the word, and correct me if I'm wrong please, the word he used was combative. So here's the thing, we can't pretend that this is an actual independent medical examination because we know it's not independent. When they're going in there and a doctor who treats injured workers, who I believe said earlier has conducted these types of exams, is saying that they're combative. They're not independent because they're hired by either an employer or a carrier, and we've heard the same doctor who's done these, has experience, says that the professionals who conduct these exams view their job as propping up whatever is cheaper for the carrier, denying care and denying claims.
Do you think that those examinations would become independent if it was the claimant that hired the doctor to do the examination?
The claimant, in 99% of the cases, has the treating doctor. There are very few cases where an injured worker has an IME. And
Where do you get that information from?
That's not
Because
true.
it isn't my experience.
that an injured worker hires an IME,
Yes,
pays an IME.
yes.
How many injured workers, well, even if it was in every case, how many of those IMEs does that one injured worker hire?
Typically one at the permanency phase.
Okay, so one, right? You have clients. Have any of your clients ever been in a position to hire only one injured worker, only one IME?
Well, do you mean one IME, one exam, or one IME, multiple exams? Because in my experience, the preferred method is to keep the same IME for multiple examinations. And one of the things that my clients say to me is that they don't want to be accused of doctor shopping. So that, you know, there are some good faith actors in this system that you don't seem to be taking into consideration with your presentation.
So if there's an IME that's been hired by an injured worker who is producing biased reports, my interest is to get them out of the system as much as it is in my interest to get an IME hired by a carrier that provides biased reports out of the system. Back to this, I just don't think that you can look at a document divorced from the outcome of the case and say that this document is a good quality or a reflection of a good quality examination. We have number one on the list. His maximum was 56 in a day, or her maximum was 56 in a day.
I don't see how that's possible. Those numbers really surprise me. I'm not saying that they're not accurate, but it's shocking to me that somebody could do 56
It's
IMEs
shocking
in a
to me
day.
too. So I think that it warrants a little bit further inspection.
So
agree with that.
is it
And when
fair
you're
to
talking-
say, though, that what the group is looking for is a bit of a deeper dive? I just don't like that deep dive phrase, it's overused. But to take a look at some of the detail behind some of these?
Well,
Is
are
that
you, when you're
possible?
talking about,
Excuse me for a minute, is there a way in the data to see who the underlying treating physician is? And I'm thinking back to a study that was done out in California where there was like a disproportionate share of certain physicians and groups that were overrepresented in the sample.
Do you?
Can you identify yourself?
Yeah, could you?
This is Glenn Petrozello. I'm in, where am I?
Okay.
He did it originally in the very beginning.
Okay, all right,
And then
sorry
Dr.
about that.
Paul came in after.
So do you have that California study? Maybe you could share with the group? I know you probably don't have it with you right now, but.
No, it's a study done by the CWCI.
okay, that's like ANCR to me. I mean, well, who's the CWCI?
The California Workers Comp Institute.
Okay, thank you.
Okay. If you do have access to it, if you could email it to us to see what they worked off of, so maybe we reconvene and see what is possible to do here.
That was California data, not New York.
Yep, understood.
Right?
So I guess
the question was, like, when we look at, the underlying data, is there like an overrepresentation in that data? In New York data?
Are you asking if there's a correlation between the overuse of IMEs of a particular, a particular IME, and whether it correlates to any particular claimant's doctors?
Are there certain doctors or groups, perhaps?
In the IMEs or on the treating side?
On the treating side.
It would be interesting.
Yeah, it doesn't hurt to, as I said, share the information with the group.
We have the benefit of some subject matter experts. Elaine? Elaine, earlier, one of the committee members mentioned, maybe getting a sampling of some IMEs, and there was a little bit of back and forth what that sampling could look like. Do you have any thoughts of what would be a useful sampling that the committee could actually use?
To evaluate the quality of the IMEs.
That's a very good question, because we get a lot of IMEs, and very honestly, I'd like to think about it a little bit.
Okay, fair enough.
I don't want to, because there's just so many variables in what I would define as a quality IME, and even the discussion hit upon many of those points. So if I may present my thoughts, either in an email or at the next meeting, whatever, however you'd like me to work it.
Okay, thank you.
Thank you so much.
I think when you're talking about outcomes, you're talking about case outcomes, not medical outcomes. Is that what you mean?
So, and thank you for helping me clarify. Take a look and see whether the IME's report was relied upon, wasn't relied upon, modified. Medical outcomes, I mean, we can certainly look at that, and ultimately that's our interest here, is to improve medical outcomes, to get people who are injured at work the care that they need as quickly as possible, right? That's our interest. So, maybe medical outcomes, but I want to go back to the point that I was making about the volume. Even if every injured worker hired an IME, and I don't think it's anywhere even close to that, and I think that the vast majority of IME use in the system is by carriers' employers.
You and I don't disagree on that.
So you asked questions about an injured worker hiring an IME. The financial incentive simply isn't there. You have one injured worker, right? How many possible opportunities? How many possible opportunities, right, does that one worker have to choose someone to conduct the test?
Does that worker, do you think, find that IME doctor on his own? Does that worker own?
I beg your pardon?
Does that injured worker find that IME doctor on his or her own, or does that injured worker rely on their attorney or perhaps their union for help?
Do you have any insight?
It's a question.
Yeah, absolutely. I'm sure that they do.
So perhaps there's volume there as well, right?
There is, but okay. I think that we're looking. It pales.
It may, but it's not. We're not talking about one individual, one time necessarily. There's a system set up on both sides. These are not absolute apples and oranges as you're presenting them necessarily. They're different. They're different kinds of apples.
Maybe an apple and a pear.
May I? I think the difference between a carrier IME and a claimant IME is that the claimant's bar, in my experience, doesn't use the middleman. They don't use the IME entities. They go directly to the IME more frequently than not.
And are you saying that that's a better process?
No, it's an observation.
Okay.
But I understood our charge to be to talk about the IME process, not to talk just about carriers' IMEs.
Like I said, from my perspective, if there's bias on the injured workers' side, then it's in our interest.
Yes, but we came to that point in the conversation. We didn't start at that point in our exchange.
May I take just 1 minute, and I apologize to everyone for waxing philosophic here, but it's a concept I feel is important. We're talking about case outcomes here, as opposed to the quality of the best medical opinion. So forgive me for introducing a small personal anecdote, but the point of this is that there are legitimate differences in medical opinion, just as there are in legal opinion. Matt Mead and I don't always agree. In fact, when we're sitting across the table, we very seldom agree. I broke my scaphoid a year and a half ago, which I'm sure most people in the room don't know, is a bone that gets very bad blood flow and is very difficult to heal. I went to my attending doctor, who took a CAT scan and said, "You need surgery, and you need it right away, and we've got to get you in about a week and a half." Another doctor offered to give me a second opinion, looked at the CAT scan and said, "Well, I'm not thrilled with this. I'm going to get an MRI." Then looked at that and said, "Actually, I think your fracture has no hint of avascular necrosis, and in fact, it seems to be bridging nicely. I don't think you need surgery. I don't think you should go in for the ORIF, and I think you should let this heal on its own, get out of that cast, and you'll be fine eventually, and you don't need this procedure, and you should not be saddled with never being able to go through a metal detector in a courthouse for the rest of your life." I didn't get the surgery. My wrist is fine. I have perfect motion. I have perfect use. I have perfect strength, and I don't think either doctor was being disingenuous or false in their opinion. I think people differ in opinions from time to time, which if we're going to focus on the quality of the medical outcome here, Really, that should be the focus. And forgive me again, I think you're going to find a very difficult time creating judicial decisions as a litmus test, because as wonderful as the WCLJs are and as hard as they try, they're not orthopedic surgeons. They're doing their best. And so I will be quiet with that. But again, let's keep the focus in part on the medical outcome. That was two different doctors, both of whom are eminently qualified, and I could name them both. They just didn't agree on what should happen.
So the thing to remember
If the difference,
is that there are different kind of IMEs. Some are treat, no treat, or how to treat, and some are permanency IDs with IMEs, which may have to do with the ultimate recovery that the injured worker is allowed to receive. And they're birds of a different stripe, and they're both significant and important, and they require, I think, truly impartial observation. And I think the system is well served when the IME is, whomever hires the IME is credible and believable, and whose opinion is valued by at the end of the day, by the judge. And I don't think the payers are well served by having doctors that always find little or no disability, and nor do I think the claimants are ultimately well served by having doctors that always find that they're totally disabled, regardless of how far along they are in their care, or in their recovery. So I think that it's a two-way street, but I think insofar as we're talking about IMEs, it's important to distinguish where and how they're being asked for and for what purpose. So sometimes it's a medical issue, but sometimes it's not so much a medical issue, it's a dollar and cents issue.
One thought I have on, I think those are good points, and I think what's important as a treating orthopedic surgeon is if you're a treating orthopedic surgeon, you view a patient differently than if you're doing an IME exam. I have, and I may be completely wrong, you guys can discuss this, but my thoughts are if you're treating patients and you're also doing IMEs, you kind of see things from both sides. My biggest concern is the doctors who are retired, semi-retired, and their only job is to generate these high-volume IME reports. And I think they have a very biased opinion. So perhaps a suggestion would be to have doctors required to have a certain percentage of their practice be IMEs and a certain percentage still treating patients. The chiropractic suggestion I thought was a little skewed in one direction, but I think that treating physician may have a more honest opinion than someone who just does IME exams for a certain side.
All right, does anybody else do want to take a break?
May I add one thing to that?
Sure.
I'm sorry. You may be only because I know a couple of doctors that are very reputable orthopedic surgeons that are very recently retired that are still doing these IMEs, credible or not. I have no opinion on that. But perhaps that same concern could be addressed by requiring people, if they're going to do IMEs, to do some for the carrier and some for the claimant. Maybe, as I'm saying that, maybe that's not the best thing, but certainly we keep a little bit of that objectivity.
Well,
there.
one of the things we want to talk about after the break is training and some of the requirements, so we can get into that in a little bit more detail. Maybe.
I just want to clarify, as to people who do IMEs for claimants, first, they're not paid by the claimant, they're sort of still done as they're paid.
Well, not necessarily. I hire IMEs all the time that I pay because the carrier won't pay for them, and absent the legal indication that the claimant's attending physician refused or was unwilling or unable to do it, I can't force the carrier to pay. My recourse is to hire my own IME and pay for it out of pocket. But in fairness to my side, I took a deposition of a treating 3 days ago, and it was a schedule loss of use. And the schedule loss of use was reasonable, and forgive the particulars here, but doctor, did you measure 3 times? No. Did you measure the contralateral extremity? No. Did you do anything that the board requires in its new rules for the loss of use? No.
What new rules?
Thank you. So I sometimes hire...
after the break.
Okay. I hire an IME because I know that the outcome, good, bad, or ugly, and again, let's leave that. I'm going to get the report. I know that the guy followed the, man or woman followed the rules, because if they don't, I'm not going to pay them. And so there's a justification for me to get that. The judge may or may not like the opinion, but I know it will not be picked apart in deposition for failure to adhere to the board's rules and processes.
Well, that's interesting, because I've actually never seen one where it was actually requested. Usually what our experience is that claimant will go to another regular treating physician for that final report, which is in essence an IME. So
And that's interesting, because the board case law seems to have developed that that's not proper, and I'm not allowed to do that. I am not allowed to just pick another doctor in the practice because I think he's going to give a better opinion. That's forbidden. So anyone who's doing that, well, that's all I'll say.
You good? Did you have any follow-up questions? Yeah.
If anyone else disagrees with me, speak out. I'm always willing to admit I'm wrong, but I don't.
You're correct.
Okay.
And that's what the board panelists
All right. Before we go to the break, I think we've talked about the last bullet pretty extensively, but I do want to touch upon unauthorized IME providers, because as the data showed, there does seem to be quite a few.
I don't understand what the concern was. There's mostly out of state. How could that be?
And is that, so that's something for purposes of, that is not necessarily, because a stakeholder, because remember the data was generated from stakeholder conversations last year. Someone mentioned it, we're bringing it back up to see from all of your collective perspectives, are you aware that there are unauthorized IME providers that are a potential problem that this group needs to address?
I see them as necessary in many circumstances. There are many people who have back injuries and move to a warmer climate because they feel that they're more comfortable in the warmer climate.
Okay.
So, it's in those instances, if an issue for an IME comes up, we're basically compelled to have an unauthorized IME. And I think it'd be very difficult for our New York board to attempt to authorize IMEs in the Carolinas and Florida and so forth and so on.
And speaking as immediate past president of the Injured Workers Bar Association, I concur with both speakers that this has never come up as an issue that is problematic to us.
Okay, well, I think that's good to know. Again, the report was based on information that was shared with us. We felt an obligation to bring it back to you. And so, whether or not we even acknowledge it, we'll talk about the logistics of the final report, that this was discussed, and, the point that you raised is noted, and then we can just kind of move on. So that could actually be the first thing we all agree to.
We're working towards areas of agreement. We are.
Not a significant issue. All right, so why don't we take a 15-minute break and rejoin. Back at what time is it?
It's 1:24.
So.
I spoke to Elizabeth Luck. She's going to speak to you this afternoon and then speak to me.
So why don't we say 1:45?
Thank you. Skilled, everything you would want in an opposing.
All right, it's 10 to 2, so why don't we get started? Was everyone back in remotely? All right. Manhattan. Oh, the doctor. Is the doctor still in White Plains somewhere?
He's just right outside.
Okay, just let him know we're about ready to start, please.
Okay.
Pardon? Okay. All right, and one more thing as a housekeeping rule, if you're having conversations, probably not so much a problem in Rochester, but White Plains, you might want to hit the mute button so we don't hear you, unless you want us to, but. All right, thank you.
So he's talking to himself there. Rochester, he might want to hit the mute button too.
His imaginary friend. All right, so we'd like to kick off the second part of the meeting talking about the integrity of exams and IME providers. The next 3 slides recap topics in the integrity of exams and providers category. The first is training. The 2015 survey was included as an appendix to the IME Utilization Study. This slide summarizes those responses regarding IME provider training. Similar to New York State, 20 states have no special requirements. 7 require passing a certification test or a course. The states are listed on the slide. Of those 7, 6 require providers to enroll in specific CME courses. An additional detail for each state is included in your handout 3. Credibility of all reports was raised by various stakeholders. This includes whether the report is a fair representation of the services actually performed. The report types include IMEs ordered by the carrier, medical reports completed by the injured worker's treating physician, IMEs requested by the injured worker or their representative, and record reviews. Several stakeholders also mentioned the existence of a listing of IME providers to whom they no longer send IME referrals. For various reasons, including submitting timely reports, whether past IME reports were included, and whether the IME provider answered all of the requested questions. The exam preparation file review topic was also mentioned by the stakeholders. It refers to the IME provider's access to all relevant medical records, as well as whether the physician or some other office staff actually reviewed and summarized them prior to the IME. Additionally, it encompasses the review of diagnostic films brought by the injured worker to the IME. The existence of overseas record reviews was raised by one stakeholder. It refers to engaging overseas vendors or staff to compile injured workers' medical records. So, just as we had earlier, we've outlined some suggested follow-up questions to that data. But in advance of even starting with those, does anybody have any questions on those pieces of the report?
Real quick, you've mentioned overseas records review and then mentioned compiling injured workers' medical records. I'm going to be candid, I am not as familiar with the overseas records reviews. Are we speaking of companies that do literally nothing but assist the IME vendor in gathering the claimant's medical records, such as the Social Security vendors help us to do, or are we talking about something more? If anyone can enlighten me on that point.
I'll refer to one of the staff experts.
Yeah. My understanding from the stakeholder that brought up was that the medical records were being sent to an overseas vendor who would compile them, put them together for a nice summary, and then that would be shared with the provider in order to complete the exam.
Meaning that the doctor is not themselves summarizing the medical
Correct.
records. Okay.
Yep.
Does anybody else have any comments on this topic generally?
How prevalent is it?
The
Overseas.
Are we still talking about overseas?
Is it, are we talking about transcription, or are we talking about
No,
drafting?
we're talking about other people, not the doctor, doing a summary of the medical records and then seemingly giving to the doctor a reduced version of what's in that record, it sounds to me. And
Is that what it is, Stephanie?
Yeah.
Okay, then we have a tremendous objection to that, and we feel that that is plainly inappropriate, wholly inappropriate, and if a doctor is going to do an IME, he should review the medical records, direct his or her staff to determine what are the pertinent parts, or do it themselves.
You don't think that this is just dictation and it's transcription?
I just asked.
I'm
They
just
said no.
surprised.
I've never heard of this.
Neither have I.
I did.
Not happy with it.
In response to your, how prevalent is this? I've never heard of it.
Okay, then I would love to know how prevalent this is, absolutely, because that's something.
We were not aware of it before it was brought to our attention, and it was actually brought to our attention by an IME vendor.
Okay.
And there's a tremendous amount of dictation, I know, that, it's translated overseas. I wouldn't necessarily have a problem with dictation.
Not for a moment.
Right, I mean, but
Summarizing what medical records say
it's
is
a very different,
matter.
no question about it. My only ask is that if we go forward in discussing this, that we draw that distinction. Just because we don't want to drive up costs for no reason.
I know attorneys that send their dictation
yes,
overseas, and that's just transcribing what the professional said, truly.
I think we have another area we might all agree.
Okay.
Okay.
Okay, I like that, making fun of this. Okay, so the first question is, should there, and it kind of ties nicely to what we were talking about just earlier, should there be required IME provider training? above and beyond the existing model.
Is there currently any training for IMEs?
Well, they must be, how does someone become an IME? Let's start there.
I have no idea.
Well, there are
They have to
specific
be-
requirements
they have
in
to be
the
statute.
in the regulations.
Okay.
About what the board takes into consideration.
And they have to be board certified in their field of specialty.
Okay.
And I believe even passed upon by the county medical.
If they're a physician, yes.
Oh, judge, okay, thank you.
Okay. So above and beyond those requirements.
Well, doesn't the board reach out to doctors from time to time when they roll out a new program and they want them to understand how to do those particular reports, schedule loss of use, whatever it is? But I don't know if those are required or not by the net.
They're optional. You know, we put them up, and whoever wants to avail themselves, we'll try and offer CME to incentivize them. Yeah.
In the vein of everything else we've touched upon today, I would be a little concerned about adding additional requirements at this point to people being able to do this. I generally find, subject to other people's inputs, that, you know, whatever their opinion may be, whether it's a treating or a carrier's IME, they're fairly well educated at the board's requirements, rules, regulations, what they need to do, and even the new guidelines. It's not hard to get over on a doctor with cross-examination where you say, do you use the 2017? And they say, no, I use the 2012. So the IMEs, I find, are generally pretty up on this. And again, subject to everyone else's input, I would not want to put any more hurdles in the way of doing this, but it's just a thought.
My experience, I think the IME entities, those middlemen that we were talking about earlier, push a lot of that new information out to their IME panels.
Okay.
And, you know, I have seen cover letters that specifically say, use this impairment guideline in coming to your opinion. So, on the IME side, I don't see a particular need for additional training.
Rochester, White Plains, any additional comments or thoughts from you?
No, this is Winston Kwok from Outlier, and we were just discussing a little bit about the requirements for impartial specialists, because I know that to become an impartial specialist under workers' compensation, there is additional training that's required. And I was thinking, like, why not have a similar training that what impartial specialists have to do with the IME provider, have a similar training course, because we're typically doing similar activities and tasks.
Yeah, it's Rick Weinstein again. I agree that some training would be helpful. My concern is we're already not having enough, presumably not enough doctors doing the IMEs. I don't want to make it too restricted where it's difficult to get doctors to do it. But that being said, I think better training would be better. And if we do offer CMEs, I think that will be an incentive for people to do this. If it's possible to also do it online and do it on your own schedule, that would be even better.
It is done online, and CME credit is provided, so that should help.
Yep.
And I was suggesting maybe we can kind of cut down on the administrative burden. Like if there's any way of simplifying that administrative burden, I think that's a key way of getting more IME providers on board.
Absolutely.
I guess on that point of whether education should be or whether it would make doctors want to do it or not, I'm going to defer to the doctors. And you could also do a middle ground, which is not mandatory but voluntary, whereby people like Matt and I would ask the doctor that when they started the deposition as a point of credibility.
Rochester, do you have any thoughts on training?
No, just like I said before, I think the vendor companies are good at that. They keep the IME doctors pretty well abreast of the changes in the laws, so I don't think a heightened need for training is necessary.
Okay. And it's available online, you said, so, because I think when this issue came up in this context, because, you know, earlier we were talking about the lack of IMEs in certain parts of the state, so the question then became, is that in part because of online provider training, or the lack of availability of training, and it sounds like that really isn't an issue. So, do we agree?
Well, I don't think that people know. I wasn't aware that there's something online available for training. So there's no awareness, at least as far as I know, that this is available for training.
No, not currently. I think Dr. Kwa was saying that there's something like that for impartial specialists that
okay.
potentially model something after. Is that correct, Dr.
That's
Kwa?
what that was always pertaining to, that there is something for impartial specialists that we do get CME credit for, that the course is done online, that like you said, can be modeled and then probably made available to IME providers.
Doctor, is that training substantive medical training, or is it training that has to do with the board's impairment guidelines?
It's pertaining to the impairment guidelines, and there is some medical training that's also involved, but majority is pertaining to the medical guidelines.
If I may interject, I believe what Dr. Kwa is referring to is the training on the medical treatment guidelines, if I'm correct. They will have CMEs reestablished. Their CMEs just expired, so they will be reestablished for CME credits. So that is something that we ask the impartial specialists to partake in, so that they will have an understanding of the medical guidelines as they apply to questions regarding treatment.
And certainly if the board were to offer such educational processes to all physicians, I very much enjoy my CLEs, or at least get a benefit out of them, so perhaps that would not be prohibitive in terms of getting people to participate.
Maybe it could be optional and not required.
I think that'd be great.
All right, on the reports themselves, are there credibility issues from your experience or that need to be addressed, or how would you address them?
Credibility issues exist on a examiner by examiner basis. You know, they can appear in any case, but you know, it's pointing out credibility problems, I think, is one of the primary jobs of the claimant's attorney during cross-examination.
I will add only that I do tend to take issue more with records reviews than with IMEs in general. Not only do I find that that's a less valuable form of proof, I find that it is a cold and impersonal way to render a medical opinion that often is lacking in the fundamental elements of a medical exam, such as a physical or a conversation with the claimant. And there was a case in the Southern District of New York that particularly concerned the claimant's bar this past year. And so how that will be dealt with, I'm going to concede I did not come prepared with a slew of ideas to this. But I deposed a physician for 50 minutes the other day and it was a records review doctor on the issue of a motorized wheelchair, where the gentleman would not concede that a claimant with a neuropathic drop foot condition on the right side and a consequential left knee injury might have difficulty ambulating. Would not. Well, I don't see why. I don't see, and there's nothing I can do about that as an attorney except my job. But I've, in addition to any issues that may be outside of the system, it's just a more difficult mode for me to accept something adverse to my client, and, well, I'll leave it at that.
You're pretty sure you're going to win that case, though, right?
Probably, but why should I have to go through 50 minutes and then go to my cardiologist once I'm sitting there after the deposition? Come on, just calm down. And you know what? Being a principal in the firm, that's not going to help me. But but they tend to be a little bit more worrisome to the claimant's bar than the IMEs that are formal, that come out, because my client can say, yes, this happened, no, it didn't happen, I disagree with this, I do agree with this. I get some where they say the doctor was as pleasant, he was more pleasant than my doctor, and you know, the opinion is what it is, like it, don't like it, but we don't like the cold records reviews.
Is that example, though, more the exception than the rule? Because then that really leads into, like, how valid of an issue is this for this group to try to address?
I guess I can only answer that by saying it can be. I'm not going to say, nor would I ever, that all records reviews performed by nurses, doctors, or otherwise are disingenuous or meant. But again, even on the idea that I would still prefer my client to be able to answer a doctor's questions or to have the doctor ask questions if need be. Again, for a doctor to get up in deposition and say, well, I say no to this treatment because this didn't happen or this is not present. And I say, well, you never had an opportunity to even ask my client if it was present. And I know it may be absent from the medical records, but that's not the end-all be-all. I'm sorry, please.
I just want to point out, there are, I guess, various types of record reviews. In other words, to my knowledge, we've never had one done that is similar to the one you're describing. Generally speaking, we want a record review only when we have a question of real medicine in terms of, let's say, initial like diagnosis or something where we want to get the initial document so that our doctor can review it, not to determine degree of disability, because I think you probably need to see the person for that.
Okay, and maybe I'm going to make this a tiny bit broader, which is my concern perhaps is a tiny bit less as to each particular records review and its credibility, and more the idea that it was possible for a doctor to fake thousands of these, and none of us ever knew it. And I'm concerned about that, and how it happened, and making sure that it does not happen again, and that's part of my point, I suppose. And I don't know the answer to that, but I know the records review is part of the problem, or the vehicle, the mode, was part of the problem. It's difficult to fake something in person. But pardon me, that will be my last comment on that.
I just want to comment on the credibility of the reports. What we've seen is certain doctors will always give the same findings because that's what they're paid to do. We talked about this in the first half of today's session. So I think that the doctors who are only presenting for one side or assisting one side will tend to really go in that direction, and sometimes the extreme. I do agree that the exams are much more important than record reviews, but they're both important. When it comes to the exam, it's nice to be able to actually see the person and have a discussion with them and let them tell their side of the story rather than just getting a record.
I just want to say that I think the nature of the IME, just as the nature of any report, sort of would inform the level of credibility that you're going to, grant to it, and how well a judge will look at it. In other words, if you are opining as to somebody's degree of disability and you've never even seen that person, I would imagine the level of credibility and the degree to which a judge would rely upon that report would be much less than somebody who had actually done an in-person examination.
I've never seen one of those. That'll be honest.
An in-person examination?
No, a records review on degree of disability. Never once have I seen that.
So what do you see it on? Medical issues?
Usually
yes.
treatment issues.
Treatment issues, need for medications, need for medical devices, need for surgery sometimes, need for a particular procedure, attendant to a C4 auth or a MG2. Those tend to be the bulk of it.
But a lot of those, tell me if you disagree, relate to whether the conservative measures required by the medical treatment guidelines have been followed so that the surgery is the next step.
Yes, I agree.
Okay.
Is there a fix for that type of issue, though, or is this just an issue?
It may just be.
I don't think it's
an issue that needs to be acknowledged.
I don't think it's fixable. I mean, unless you compel.
Right, more paperwork.
Yeah. You know, the medical treatment guidelines exist, and the regulations require that they be followed, and a lot of those IMEs are responding to variance requests or authorization requests for less conservative measures. I think that's an element of the system we have.
Okay.
I just want to say, if we're going to be talking about credibility, I absolutely agree there probably are problems with the credibility on various reports. I think that maybe it would be a good idea to speak about credibility just across the board in medical reports, so that maybe there are ways we can address. Because I think and I was saying this before when we were on the break, I think the goal here is to have claimants have the best possible medical treatment as quickly and efficiently as possible, and to make the system work quickly and, well. And so to the extent that medical reports in the first instance from treating physicians are as credible and as reliable as possible, maybe it would be a good idea to figure out ways to make that happen across the board, so that we could rely upon the medical that we get instead of have to litigate and evaluate it with a skeptical eye all the time. Maybe something along the lines of some sort of treatment guidelines for everybody.
Rest of the group?
Meaning
This is beyond the scope of the.
I'm just looking at, the different things that have come up in the
I
report.
think that it's all part and parcel of a similar issue. So I'm just suggesting, if in addressing the IME issue, we were able to sort of come up with some guideline that everybody could look at, and that would, make life easier in terms of assessing degree of disability, maybe that's something we could consider.
The actual exam, possibly? Sorry.
Oh, no. A degree of disability, I will concur with you upon. Medical treatment, appropriateness of authorizations, I think the board has pretty well dealt with that with the medical treatment guidelines. They've covered most of the body parts, and in an effort to rein in attending physicians, their treatment recommendations, opinions, to accord with best medical practices. So I think that part of it is pretty much covered.
Yes.
I agree with Joe that trying to have a conversation about corralling treating physicians.
That's a whole.
That's a different.
Even I can see that's why beyond the scope of this group.
Yeah.
We're talking about corralling, but I mean, if you were, I think it's a good idea to consider the,
But it is one of the issues that people brought up that we need to be aware of, whether or not it ends up in a final report or we have recommendations on. I think it's a valid concern.
Well, and also I'm suggesting that if there's a possible fix for IMEs where to increase their credibility and reliability, that solution might well be something that could be used on both sides.
To benefit them as well.
Right.
Right. It's not necessarily just criticism. It could be something that can be fixed.
Right.
Right. Understood. The overseas records review. I guess the question that came up in the report was, should they be allowed, and to the extent if they are allowed, which you were discussing before, what should be allowed? No.
They should not be allowed.
I don't even know what they are.
No, they should not be allowed.
If it's someone else summarizing the contents of medical records for the records reviewer or IME, I don't think that should be permitted. So I agree with these guys.
But with Mr. Ginsburg's notation that the bare administrative functions can be done any place, just not.
Sure, if I'm a doctor and I dictate my report and it goes to the Philippines to be transcribed, that's different than it going to the Philippines for somebody to say, this report says this.
Yes, sir.
I can't agree with that.
About the transcription overseas?
Yeah, I can't.
Why?
Why?
Because, I mean, the function of, like, my job is to represent workers here in New York State.
How does this harm them?
I cannot possibly put my name on something that says it's okay.
It's okay to offshore transcription.
Can't do it.
No, all work should be done in New York, period, bottom line.
Well,
that's also-
so here, Justin, I don't agree that all
I
work
was
ever
not
should be
being
done in New York,
facetious.
but I think that all work to support the workers' compensation system should be done here in New York.
No, you
Yes.
missed my point. I was not making fun. I believe that all of it should be done
Well,
in New York.
disposing of nuclear waste should be
Fair enough.
Totally
But no, that was not at all.
With respect, Joe, and I'm not
No.
calling you out on this at all, but with respect, I mean, that's not part of the scope of how the system would work here. I mean, if doctors are...
Here's the thing, Lev. I cannot agree to that. I mean, we fight this all the time. We passed a bill to specifically stop this type of offshoring
Outsourcing
yesterday.
work.
Yeah, I mean, I can't. It has
can I
nothing
just-
to
can I
do
We're
with
interject?
not really, we're just,
That's
we're
right, it
not
has
really
nothing to do with this.
recommending that it
That's
be a
all.
practice.
So that's
that-
why it should not be included here.
We're not including it, we're just not
We're not
excluding
gonna,
it.
exactly.
Well, that was not my understanding, and thank you for pointing that out. I thought that we were looking for a caveat saying that.
No. We were
Okay.
specifically looking for a caveat that said you may not outsource medical opinion making or
Yeah, yeah,
medical.
right.
We're not saying, we're just.
Well, in that conversation, I thought you were also talking about adding a piece.
No.
That
Not
was
specifically doing
what I
either one
understood.
on this, just drawing the distinction between.
And again, this is the
Yes.
product of what came in the stakeholders' conversations. There probably, as we go through the topics, will be something that one person brought up, but we feel compelled to bring back to you. If you as a group decide you don't want to include it in the final report, then that's the final report. You see what we just feel like we gotta, return the information back to you so you know what people are raising.
Okay.
Okay, so I think we're pretty clear on that one. And then, are there opportunities to improve exam preparation and file reviews generally?
Before we get to that, could
Sure.
someone tell me what an IME non-referral list is?
It's when there's certain carriers will have a list of like a do not call list.
Oh.
We're not going to use these IMEs or IME entities.
Okay.
I'd be interested in learning more about that.
As would I.
If a doctor routinely provides late reports and never gets them in on time, you don't want to use him.
Is that the only reason why they would be on a do not use list?
That would be my
He's
question as well.
Could be a terrible deponent. He might write a great report and then isn't available for testimony regularly.
So is it just availability and timeliness?
I'd say primarily.
I had this conversation during the break with somebody about when I'm asked for recommendations on IMEs. Typically, the question is, who has credibility with the board, who will produce a report that we can stand behind. I don't get questions about who will give me a no disability report.
Is there, and as I
Do you
read
think
the-
that your clients are savvy enough not to ask that question?
I don't know. I can't answer that.
Is
but-
there
Is
any
there a list?
prohibition on a carrier putting an IME provider on the list for being too costly, approving medical treatment that's too costly, or okaying treating providers
You mean,
assessment of disability?
Does the law prohibit it?
Well, does anything prohibit it? Do the carriers have an internal practice that prohibits it? Does the law prohibit it? Do they have like just cause protection for discharge?
Not that I'm aware of.
I would be interested in learning more about the list and how
There
doctors.
is not a list from a generic list.
Well,
There are
the
doctors-
lists that carriers or employers use, how IMEs end up on the lists. That's something that I'm really interested to learn about.
I mean,
Go ahead.
there is no list.
Well, I
That
think
that
inherently, in my own mind, you're a professional and you are going to recommend or not recommend people to somebody, whatever
Are
it
there
is.
doctors that employees don't go to?
Correct. So.
If there's a list, then
But
Well, there is no list. There's a list, just the same list. Like
that
the
list-
attorneys know who not to send their clients to.
let's ask them about it.
I'm not so interested. I'm interested in moving forward and getting something good here and making positive change here.
I am too, and I think that understanding a little bit more about these do not refer lists or do not use lists is part of that.
I think though, think about when you go to like a dentist and the dentist is going to give you a referral for your oral surgery. You can take that and throw it in the garbage and go to your own, or you can base it. So to the extent he's doing a referral, there's probably in this field a like list that he may say, don't use this guy.
I'm interested to know, and maybe we can ask the IME entities if they come in, if they keep different lists for different carriers. Like they have, just say, 100 doctors in their pool, and they know that carrier A doesn't want 5 of those, or carrier B doesn't want a different 7. I think that this is something that we should at least ask about. I don't understand what the hostility to finding out the information is.
It's fine. I just want to say, I also think, from my experience with the IME companies, they want to use every doctor on the panel because they also, as I said, they don't have the largest pool. They want you to use everybody on their panel. So I don't think they have any particular interest one way or the other.
So then we can talk to them about
Absolutely.
doctors who are no longer on their panel, maybe.
Stephanie, this came in from a
This
stakeholder?
actually came in from several stakeholders, that there are certain IME providers that they won't use, and no, so it could be because the reports were precluded, or they're not timely, or they, failed to hold up under deposition. They all alluded to the existence of a list. I don't know if it's a paper written list or if it's what it is, right. But that there are certain IME providers that they have made a decision not to use anymore.
And I think, one of the things we talked about before was potentially bringing in the IME providers for a subsequent meeting. So that could be the time when we revisit that. If there is a list.
Other carriers or Brian from Wegmans, I don't know if they had any comments on
Rochester, White Plains?
Or what? Last
We don't have a list. We use IME Vendors, and we use doctors off that list based on prior history. I mean, it's just like there's different restaurants I go to that I like. There's different restaurants I don't do because I don't like. I don't know what we're trying to figure out here, but it's a list that we pick up doctors off of to use to treat our people. I don't know what the issue is.
What are some of the reasons?
That's a great analogy.
I'm sorry, Brian. What are some of the reasons that you wouldn't use someone? I think that's what Joe's getting at, right?
I think we've already mentioned it. Or maybe reports were precluded. They don't know how to file reports on time. They take a long time to schedule. All sorts of different reasons. It's not. I don't think it's a thing that I don't like this doctor because he found 100% disability in somebody. I don't think anybody's looking at that.
Well, I would disagree. I think that does happen. I'm not going to say that it's the majority of cases, but I think it would not be honest to say that there are not. I mean, there are good lawyers and bad lawyers, and terrific lawyers and horrible lawyers. There are some carriers, I believe, that have made a determination that there are certain doctors that they would rather not use because the opinions are generally not favorable. And I've seen it in my close to 2 decades of practice, and I'm not going to say that that's the majority, probably the bare minority, but I don't think it would be fair to the table to pretend that that doesn't happen.
Did someone in White Plains want to chime in?
No, we agree.
Now, how to fix that problem, I can't even begin to tell you.
All right, and then the last, opportunities to improve exam preparation and file reviews. Are there opportunities?
What is exam preparation?
What's exam preparation? That's again getting the medical records together so that it came up as a stakeholder comment that it's not necessarily the doctor that's pulling the records together and reviewing them, that it could be some other staff in the office.
Oh, so it's related in some way to the overseas.
Yeah. Continental.
But it's okay. It's domestic.
Yeah.
Occurring in New York.
Absolutely.
But it's a very broad sort of term. I mean, what are we talking about? Are we talking about a medical professional in the office doing it? Are we talking about an administrative assistant doing it, or is it out of the norm? It's quite broad to sort of.
Well, that's why I'm wondering if it really belongs with the general, what we talked about earlier, which is just the administrative burdens generally.
I mean, do you expect, how does the doctor get the medical? I know how it does in our instance, but I mean, I don't expect the doctor to go through the ECF file himself and pull it. I mean, I don't know what's the method and what do we expect from the doctor?
I think we need to draw a distinction between gathering records for someone's review and actually summarizing them for the review. I don't have a problem with someone gathering the medical records and giving them to the doctor for review. As long as the doctor reads all of them, I'm not even sure I take horrific issue with someone who is the doctor's assistant assisting to thereafter write the report or help just to generate the bare report. But any interference with the doctor's opinion, I mean, my staff will set up a meeting, they'll put a little summary in it, but it's my job to have the meeting and to dictate afterwards and give my legal opinion, and that's that. So just, we need to make that distinction.
Anyone else on that?
I have all the stuff that was sent to me in this nice binder. I didn't punch the holes, but I did read the material. And I think that's the distinction we're trying to
Okay.
draw, right? Yeah.
Nice binder. All right, so it seems like to the extent, is there anything else in the category of integrity of exams and IME providers that the group wants to discuss or feels needs to be addressed?
Yeah, I just wanted, it's Rick Weinstein again. What I brought up before, I just wanted to see if there's any discussion that people want to have. The idea that doctors who do IME exams say it's for the carrier and they are no longer practicing, or they're more than 2 years from practicing, or some arbitrary number that we can recommend, that they not be only doing IME exams as their full-time gig, and that they should be treating or doing something other than just doing these IMEs for one side.
I agree.
I'm not sure that I agree in the sense that, I mean, we're assuming that somebody who's a physician, who spent his or her career as a medical doctor, now retires and is going to sort of put aside all his ethical concerns and somehow be corrupted by this system. I think that's a really unfair assumption. And I'm actually basing this on a personal experience, just as Justin brought to bear his personal experience. My family had a friend, he's not alive anymore, but when he retired, he worked for, I think it was the police department or somebody, and he used to spend so much time reviewing records, doing exams, and I don't know that his outcomes weren't one way or the other. And I think to assume that somebody who's retired is necessarily going to be pro-employer or in favor of the employer, I think it's an unfair, assumption, and I think it's really painting with too broad a brush.
I think most doctors are very reputable and have good integrity, but it's not all the doctors, and some of the high-volume ones do concern me because this is their full-time job, and they know some of the referrals they're getting are specifically because they're giving those favorable reports.
I don't know that that's...
I'm not certain that we fix that by assigning, as in your words, an arbitrary number. I think and he's not here to defend himself right now, but I think of Dr. Goldberg, for instance, who I've had the privilege of sitting on the Medical Advisory Committee for 7 years with, and his expertise, when I agree with him or disagree, I think is without question and blows me away, frankly, with the depth of his knowledge. And if Dr. Goldberg decided tomorrow to stop treating patients, I think it would be ridiculous to not be able to rely on his expertise in an IME, especially if we were to set an arbitrary number like a year or 2 years out of practice. I think that it's a mistake, and I think that if there's a question to that doctor's ability outside to perform an IME sort of outside of a certain number of years of practice seeing patients, that may be a question, for re-upping their licensure or their approval by the board at some point. But certainly I think it's a mistake to just arbitrarily set a number and say no.
I agree wholeheartedly with Lev. We should not set an arbitrary number. We should not permit it at all. I understand that there are people who maintain their integrity and their credibility. There are other things that they can do. They can go out and do they can do medical examinations for liability cases. This is a matter of preventing bias or eliminating bias in the workers' comp system here. It's not a matter of retired doctor reemployment.
We'd be losing a tremendous amount of expertise, don't you think?
Do you think that there is no?
Don't you think that there's more bias that high volume individual practitioners having high volume number of exams is more indicative of bias?
You mean on the treating side?
Than being retired or not?
Well, I think that you see a strong correlation in the numbers here. We can say retired. Retired is not the right word, but no longer treating. I think that you see a high correlation in the volume here and the folks who don't treat.
So how many times would they have to treat somebody to qualify in your election system? Was it one person a year? Is it 100 people a year? What would you pick as a number to have considered a treating physician?
I'm open to suggestions from the group here, but I certainly don't think that one is sufficient.
So maybe there's another way to get at that bias problem, is what I'm hearing from others.
Well, that goes back to my suggestion. If everybody had more of a level playing field in terms of what the results were and how to evaluate them, maybe that would be a way to eliminate a certain amount of bias from the system.
Okay, I think we've essentially covered all of the topics we had wanted to.
I have one more, I'm sorry. I apologize. One other piece of information that I think would be helpful is if the carriers or the self-insured employers can share with us whether they have written claims handling practices or policies that dictate their use of IMEs. And if they do, if they'd be willing to share them with the group.
I would think most carriers and TPAs would consider that to be proprietary.
Okay, so is that confirmation of the existence?
I think it's privileged.
Joe, I'm sorry. I was listening intently and I wasn't writing.
If whether or not the carriers and self-insured employers have written claims handling practices or policies that govern or dictate their use of IMEs, I think that based on the gentleman from Amtrust's response, we can confirm that they exist. Whether any would be willing to share them with us, with the group.
Hey, you didn't speak.
I beg your pardon?
I wasn't going to speak. Was that Brian?
I thought it was Mr.
No, it was
Petrozello.
It was this gentleman.
Yeah. I'd say most carriers, TPAs, have written best practices, but it's proprietary, it's confidential information, it's their secret sauce, it's how they do their business, and to share in a public forum, I would say most would say no to that.
Well, would you consider sharing it with maybe a designee from the board who could take a look at a few of these and put together some bullet points for us about them?
Joe, I just want to say, I actually did tell you exactly we don't have anything that I can recall that's written down, but we do an RFP for our IME companies. After that, we have a rotating wheel that we don't know who's going to come up. We send it to an IME company, they send it to a doctor. That's our process.
Well, thank you for sharing. I'm wondering if anybody else would be willing to share theirs.
Yeah, you can check ours off the list. We don't have any list that would exclude or preclude doctors. We have best practices, but doesn't reference anything about IME and who you can use or who you can't use.
Well, anything about when or whether to use, or when or whether to strike someone?
Remember, an IME, I said that before, it's a litigation tool. I wish we didn't have to use them. I'd be happier if we didn't. But that essentially, usually it's the judge saying, City of New York, get an IME.
I understand you've explained your practice a couple of times. I don't know why you're taking issue with me asking other folks about their practices.
I think you're harassing.
I'm not harassing anyone, Mindy.
Okay. Hi. No. Because I don't see the relevance of this. I think it's a little bit like a fishing expedition.
I don't think it's a fishing expedition at all. We're here to talk about the use of IMEs in New York State. And if there's a written policy or practice that governs the use of IMEs in New York State within specific carriers or TPAs, I don't understand how you could even argue that it's not relevant to this discussion.
Because the discussion is, how do we think this should, what do we think this process should look like? It's
Correct.
not about what are the problems. We've looked at this, we know there are problems, we all agree on various levels that there are issues here. Why do we have to go and see how people are dealing with each of these problems on their own, in their own practices?
We've gotten information. The board has provided us with information. We've all agreed to seek information from other sources. I'm asking for a piece of information. I don't understand the hostility, though, to it.
Because I don't see where you're going with this, except to point fingers and say, oh, look what everybody does. I think what you're looking for doesn't even exist.
Certainly not. We've already confirmed that it exists. Certainly not. But if there is something in there that dictates that they should use IMEs on cases involving a certain dollar amount, I think that's important to know. If there is something in there about when or whether not to use an IME, I think that's important to know. We're talking about
part
the
of the
system.
problem, Joe, is that you know that in the cases that you're asking about, whether it's a carrier or a self-insured employer, is that there's about a 99% chance that would be privileged information. So they're going to have to say no to your request nonetheless, regardless. And you know that. You knew that before you asked. And that's what I think Mindy was getting at. So I understand your point, and it's fine, but what you're asking for is how an employer or their carrier decides to proceed with a litigation, right? Within a litigation. It's privileged information, and you know it is. So it's not really worth discussing. You can absolutely ask an employer that sits at this table, and they can decide whether to answer your question or not, but to ask it in sort of an overall fashion and then make presumptions that it must exist or it mustn't exist when you know it would be privileged if it did is just improper. We both know that's true.
This is not litigation. The question of this, we're not in litigation.
No, you're correct.
The question of privilege aside, right?
You can't put it aside here.
We're not. Our task wasn't to only seek information that's not privileged. It was to take a look at the system. And the other thing is, I'm not seeking to compel anyone to share anything. Privilege can be waived.
But don't assume, and don't make assumptions when you're told no.
I'm told no, what?
When they said we wouldn't be willing to share it because it's proprietary, you said we should then assume they exist. So I'm saying we can make no assumptions other than even the question would be privileged.
Glenn, are you comfortable confirming whether they exist or not?
This is one entity.
He's the only person we have to ask.
What is it that you're trying to confirm? What's the it?
Whether or not they have claims handling practices or policies that govern their use of IMEs.
Can I ask you a question?
You've been all day.
No, I've been mostly pontificating.
And you've both been having a very nice all day, back and forth, until this point.
Have you ever practiced before the board?
I have never practiced before the board.
Okay, so I think maybe that would help inform an answer, because IMEs are generally done as a request or the behest or the direction of the board. Not always, but frequently. It's not...
So are you suggesting that because, in your experience, the board has directed IMEs?
You're asking for when do people decide when to do an IME, what's the process, and I'm telling you
You've told me your process 4 or 5 times, I get it.
No, this is different. I'm telling you that the people do it at the behest of the board. It's not like I wake up in the morning and think, I mean, sometimes it is.
You're too close to this, Mindy.
That's true. But I think if you understood a little bit of the process better, you would understand that the question isn't really so on target.
I'm a perpetual student, and I'm always interested in learning more about what I do and more about the Workers' Compensation Board and the practices of workers' compensation carriers and TPAs here in New York, and I'm seeking to learn a little bit more about it. That's it.
And I think when I'm hearing the group saying this is probably not the forum to have that conversation.
Is the group saying, like, nobody is interested in this, that everybody else agrees, Justin, you too, that this is not possibly helpful information for our task from the legislature?
I don't think they said that. I think that for purposes of developing recommendations for the legislature as to how to improve the current statute, that this piece of information is going to be a bit challenging for them to share.
I do have one thing to say, though. The point of the IME is not a litigation tactic or tool. It's to get to the truth, the best medical truth.
Right, but I'd be happier if we could get to it sooner in the process. And if I felt I could rely more, if I could more reliably, find that the claimant's doctor is credible and not just total disability, I would not need the IME. And I'd be happier, and I think the board would be more efficient for it.
Probably, but thank goodness you have the ability to get the IME. Just so you can combat that very situation.
Right. No, I think that's...
Okay, I think we've...
To be clear, my request stands.
Okay.
And
we have a mailbox. I mean, nothing stops anyone from actually writing into it after they listen to this.
No, and as we go through this process, I'm sure that there are going to be questions that come up that can't necessarily be shared directly within the public forum, that maybe there are alternatives to get that question answered.
thank you, Michelle.
All right, so I think, surprisingly, I think we do have some consensus on a couple topics that we've talked about today in the IME category. The first is probably, there's a general consensus from the group, I believe, that we need more providers. And how we get there remains to be seen, but there seems to be a consensus on that.
Can I add something?
Sure.
It seems that a consensus might be that an investigation as to appropriate regulations and the level that are appropriate now would be part of that as well.
Absolutely.
Okay.
So I want to, because I feel like we're at the point of the show where if you don't speak up, you're going to be, here's the thing, I don't know that the numbers aren't sufficient. It does, though, seem that regionally, there are a lot of folks, so maybe not the numbers of the providers, but the number of available, examination slots, if you will, because it seems like we have a lot of providers that are underutilized, and then very many who I think that we have consensus are really being overutilized.
And so I would characterize what I said and then clarified by Joe would be there is a consensus on providers on really where they are.
Well, I think so that generally we need more providers no matter where.
And you've identified, we took note of the fact that, believe that New York City still does not have enough.
Right.
There's still, so then that gets to the next.
I think White Plains.
Oh, I'm sorry. Go ahead, White Plains.
Okay, so the clarification I would make is clearly we can get doctors to do exams downstate, but we would all be better served if there was a broader group of doctors available to do those exams. And I think that would also speak to this concern about the volume and the reliability and the outcome predictive nature of people that do high volume work. And I think even in places where there is availability of IME providers, meaning the physicians themselves, we would all be better served if there were still more. That would be the only thing I would say.
And I think...
Obviously, I'm saying where there are few, obviously there, all the more reason.
And I think that, anybody else have anything on the other offices? I think then that ties to The other thing that was pretty clear that, earlier on was the need to potentially examine the administrative paperwork burden. And what is it that we could do to minimize that, to encourage more people to become IME providers. And so the suggestion was thrown out that maybe for those of the group that are interested, we form a subcommittee to, rather than review all the paperwork here with this group, have a subcommittee get together, look at some of the issues, and then report back to the greater group. How do people think that would work? Is that okay? Does everyone want to be on the subcommittee? I mean,
Looking at what
everyone's
Bernie's
looking, right?
I would be on that subcommittee if there were others.
If Justin's on it, I'll be on it.
And if you had a live one, Joe was. So
Are we
White
in?
Plains
Are we in
and
live?
Rochester.
If you're in, man, I'll do it.
Let's do it.
All right.
Wait, can I get put on that committee too?
Yes, we need providers.
Well, the idea is that, the group would get together offline and have a productive conversation and, report back with some recommendations as to what can be done and report back to the greater group.
So who, oh, Dr. Weinstein.
Okay.
Yeah, I would like to be on the group.
I have a feeling that would happen.
It's going to become a committee of the whole.
Yeah.
Yeah.
Can I ask one question?
Sure.
The medical portal, would that help in decreasing this burden at all? I don't know where we're at with the medical
Yes.
portal.
Yes.
Everyone's nodding their heads, yes.
Do you want to speak to that?
Yeah, I mean, I think that.
I was just saying, it would require a statutory change. But,
Right, right. But I do think that the capability would exist through the portal to be able to deal with a lot of the administrative burden. So we can talk about that in the subcommittee and see if we have some suggestions about how we can fix that.
To effectuate that. Okay. What's the requirement? Same day?
Yes,
Same
Dr.
day,
Same day, same manner.
Same day, same
Okay,
manner. Okay, go
Dr.
ahead.
Qual wants to be
Yes.
added to the
Yes.
committee as
Okay.
well.
Absolutely.
All right, the other area that we seem to have agreement with, that this group does not see an issue with out-of-state providers as something we need to address in the report. Any disagree with that? Okay, and then I've got third things I identified from earlier that will move to a parking lot to figure out where they best go moving forward. The first is, in the course of the conversation at IMEs, it became clear that there's different types of IMEs that specialize in treatment versus permanency, and where should we talk about that? Should we talk about that some more? Do we think that's a big issue? Because you were all kind of talking about different definitions and what the IMEs specialize in.
Before you say that, were we done with the topics of consensus?
Yes.
Okay.
Sorry.
And maybe I missed you said it, the overseas medical reviews. I thought we all had a pretty good consensus.
Yeah,
Consensus on that.
Okay.
Okay, so that's another one, yeah.
So just to be clear, on the overseas piece, it's really not just overseas, it's just anyone who's doing the medical review that's not the IME provider, right? Like
I don't
the
know,
person
we
who's
have it
conducting
in
the exam, right, or the professional?
No, I think we all agreed that it was inappropriate for.
It's not, right. And again, how we transition from the preliminary to the final report, we may just not address it in the final report at all.
So we're
We haven't talked about that.
But we hadn't gotten, I don't think we had finalized on that, but Matt had sort of made the binder analogy, and I think we're all sort of in agreement with it conceptually.
Yeah.
So we'll probably have to work on the language. But,
Correct.
Yeah.
Another point of consensus was that we might want to bring in some IME professionals.
And so, the different types of IMEs, is that something the group feels is worth a further conversation?
Different types, do you mean?
Well,
permanency,
treatment, permanency,
IMEs
exactly. You know the
versus-
terms better than I do.
Okay.
Is that something we want to follow up on? Does it belong in another category?
Do we have just like the basic data on what the breakdown is for the different types?
Or is it more, I think it's more anecdotal.
And that might be tough because many IMEs have multiple points addressed in each.
Right.
That's true.
Right.
Right,
I think anybody who does an IME ought to be conversant with the board's medical treatment guidelines and the board's impairment guidelines, whichever year they were adopted.
Did we also agree on some system of voluntary board-sponsored education?
Yes.
Okay.
Dr. Quam mentioned that.
So
All right.
Another consensus point.
Yeah. IMEs, bringing someone in, is that something people are interested in? Or do you want to do that via a subcommittee? But it seems like the subcommittee is going to be the group anyways.
Bringing
The IME
IMEs,
entities, you
yeah, an
entities?
IME
I
entity.
think that should be
I think it should be
public.
the whole, yeah.
Okay.
the whole group.
All right, I'll
Can I
defer
just
to-
clarify that though, just from our perspective? So does it make sense for us, because one of the asks was to identify the process that they use. So does it make sense for us to do a little bit of homework for you to document what we're aware of? So you have like a summary document to look at before we bring in
I do.
the IME entities?
I
It
think
makes
that'll
sense,
make
a
the
lot of sense.
conversation
You,
go.
you,
Okay,
you
so we'll-
license the IME entities, right?
Register.
Right.
Register the IME entities. So there's.
So we'll take that offline first and then come back with like a summary of it, and then you can, we'll present the summary and you can ask the IME entities that are willing to come in, any questions you want. Does that work?
And then
Yes.
is there a specific meeting we can invite them to? Only because
Yeah.
you said process, there's the August meeting. I don't know if that's waiting too long.
Well, maybe we can bring them into the June meeting for the cost of IMEs, because they may have some background on that as well.
Yeah.
Okay.
All right, and then the third thing that we thought warranted further discussion was the fees generally, and we thought we'd do that maybe in the June meeting. The project, there was some discussion on the fees this morning, or earlier. The level of fees and who determines the fees.
Well, I thought that we were discussing that on a different,
Oh, like when we were talking about incentives, right?
if that would, right.
Yeah, I
Yeah.
think that's where it came up.
That could go under cost of IME.
Okay.
Yeah.
Makes sense.
We should do cost of,
Okay.
under cost of IMEs.
This may be better served for offline, but is there any wiggle room in some of these dates?
Is there one in particular that's?
The July and the August don't work for me, but I can certainly have someone fill in. But
I
there-
think the idea when we set up the schedule was, we're already the first real meeting into it. Stuff is rolling ahead, so, we can talk,
No, it's perfectly fine. You'll all have a break from me.
But you can always, as you said, you can send somebody to represent you, which of course will be the same. Or you can send written comments, particularly, there's certain subjects.
That's fine.
We know summer's gonna be tough for everybody.
Yeah, no, I sort of figured those would be months we didn't even meet, but neither here nor
You
there.
know what, in a perfect world, I think we would all agree that maybe that was possible. But before you know it, September is here.
Sure.
And we're gonna have to turn around a report and have all of you be happy with it in a pretty short window, because I think the statutory deadline is December, right?
I guess my
December 31st.
ask is that if we're gonna have outside parties come and present, that they not be at the July and August
Okay,
meetings.
that's fair.
But the other thing is, this isn't set in stone, this is your committee, so the committee could decide what they
Yeah,
want to
you
decide
can decide
about
not to have
August
a
or.
Let's do it every Tuesday till we're done.
I think it might be every Tuesday till I'm dead. It might be before we finish.
All right, is there anything else that people want to raise or issues they feel we didn't address today? Were we gonna talk about next time, or?
For the parking lot, the information request that I've made, I'm not gonna stop making it.
Okay.
So,
Understood.
I think it should be put in the parking lot.
Okay.
Thank you.
Yep.
They could be put in lot Z.
We'll all be
All right.
walking a lot soon next week.
All right, so next month, we're talking about scheduling, which is scheduling and timing concerns, self-initiated versus directly required schedules, specialty providers availability, notice, cancellations, and then the reports. 10 business days, 20 out of state, same day, same manner, which seems to be a critical issue. So the mailbox is up and operational. So if you've got comments subsequent to the meeting, by all means send them in. And we will see you all in April.
Thank you
Good night.
very much.
Thank you.
Thank you, guys.